Yeah, exactly. Yeah, they can. And I think the greatest help we can all be to ourselves and to each other is to educate ourselves. I think that's the number one thing that we should all be doing at the moment.
Now, would you suggest perhaps to learn and educate and gain knowledge, perhaps forget what you've learned to start with?
Yeah, I think that's goes without saying. If you're going to learn something, it's most likely going to step on the toes of something you've learned previously. Um, so there it is, a learning process and a relearning process.
Fantastic.
But anyway, let me take you through what's happening,
Sure
and
thing.
I'm sure you'll find this of some interest. So I'll give you some background. So about 9 months ago, my wife and I decided it was stupid to keep paying rent, and so we decided we were going to buy a big tent, and we were going to let me share my screen with you.
Sure.
Can you see my screen?
Oh, look at that. Yep, certainly can.
Okay, so about 9 months ago, we decided to buy a couple of big tents and stop paying rent. We were paying about $450 a week in rent, plus electricity, plus water, plus internet, plus gas. And I can't think of anything else, but we decided that was stupid. We hated the house anyway. So we decided to buy a couple of tents and do a little bit of letterboxing
Yep.
to some properties that we liked that on acreage, like big properties. We live out here in the mountains, so there's heaps of places that are over 10 acres, 100 acres, etc. And we basically said in the letter, I'd show you a copy of it. I just can't find it here. But basically, it just said, actually, you know what? Let me see if it should be just here somewhere. Can you
Yeah.
see? You can still see my screen, yeah?
Mm-hmm. Sure can.
Give me a quick second, because I
While you're
think.
looking for that, Alex, are you in your
Yeah.
tent now?
Sorry.
Are you in the tent now?
Yep.
Fantastic. Looks like you're in a home. Well, you are. Your tent. Awesome.
Okay, so here's the letter.
Right.
So it's a one A4 page. That's all it is. Very simple. It says, "Dear landowner, I'm looking for a small piece of land to caretake or rent. If you need someone to help take care of your property, I have a lot of experience with land management, fencing, gardening, etc., which I can provide in exchange for living on the property. Or we would happily just pay rent on a weekly basis if you prefer. But obviously the amount that you'd be paying for a small piece of ground is a lot less than renting a house. My wife and I live in an alternative lifestyle, and we would like to set up 2 tents to live in full time. We are a quite professional couple, wanting to escape the hustle and bustle and live simply on the land. The main tent is 6 meters in diameter, and we have 2 smaller tents for a bathroom and storage. This is what the main tent looks like. We supply all our own needs with solar panels, composting toilet, and small 200-litre water tank filled from a creek, river or mains, so you don't need to worry about anything. And there's my phone number. So we letterboxed this to about 50 properties. We got about 5 people reply. They rang me and said they were interested, and we eventually picked one. So we've moved in. We're here now. We're actually right next to a river, which is beautiful. So we get all our water straight out of the river and all that sort of thing. So a few months later, after we moved here, about probably 3 months later, the Department of Environment decided to contact the landowner, and then basically told him that those tents that are right next to the river can't be there. It's on Crown land, apparently. And he goes, "What? That's my land. What are you talking about?" Anyway, so they provided some evidence that actually that section of land is actually Crown land along the river there. I think it's 25 meters from the river bank, or no, from the center of the river. Either way, I don't know. Apparently most rivers, land along the banks of rivers is Crown land, regardless of what you think.
Okay, what proof of claim did they give? Did you see it, or just the landowner did?
So we're about to get into that.
Right.
So I basically ignored them. And then several weeks later, he actually rocked up here, and we had a chat. and I basically told him where I stand, and he left. And then several weeks after that, probably about a month or so, another guy came, a different guy from the same department, along with a colleague and 2 police officers, to hand me a notice, which I have here. No, that's not the notice. Actually, I couldn't find that either. I'll get to that in a minute.
Sure.
So he handed me a notice of demand, basically saying that if within 21 days I can't supply him with a permit or some kind of something like a permit from a government authority saying that I'm allowed to camp on this land, I have to not that I have to leave. He would apply to the magistrate's court to have an order issued to have me removed. Okay.
Right.
So the 21 days has come and gone, and instead of applying for the court order, he has gone to the court and requested that they issue me with a summons to appear in court.
Okay. In that time where they issued you that demand that you mentioned, did you rebut that?
Yeah, I did. Yeah, I did.
The contract?
I did. So let's go through that now. And I'm going to show you what I've done.
Sure.
Okay, so this is what I've sent him. And I'm going to go through it with you, and I want your opinion. Okay, so at the top here, I've got Alex Stefan, a living man under common law, care of the address, and all that sort of thing.
Yep. Near 3779. So you're not at post by the looks of it. Military post. All right.
That's the this here is the person from the department. And the heading is Notice of Objection and Demand for Further and Better Particulars. And let's go through and read it now.
So you're just chasing a little bit of clarity there by the looks. So, Alex?
Exactly. Clarity and also getting him to prove his claim, essentially.
Yep.
So I'm aggrieved by your unlawful attempt to deprive me of my right as a living man under the common law, which affords me the right to access and use public land, a right that is enshrined in the binding constitution of the Australian Commonwealth 1900 under common law, and which to my knowledge has never been repealed or amended. I'm referring specifically to the right to access public land has never been repealed or amended. Okay, so in your notice of demand pursuant to the Land Act 1958 and dated blah, 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 you addressed me by the wrong name and with the wrong address. Oh, by the way, when he came here, he asked me for my name and all my details and to show him some ID. I didn't do that. I refused. And I said, I don't need to show my ID. You already know that. So he didn't get my ID. But what he did was he went to the landowner, and the landowner gave him my ID because he had a photo of my license.
Right.
So he obtained the license from someone else. It wasn't me who gave it to him. Okay. So I don't even know how that would stand up in court. But anyway, so you addressed me by the wrong name and with the wrong address. Please note.
So in other words, he was referring to you as a person then, right?
That's correct. Yeah. From what was on the license.
Yep.
So I said to him, please note that I'm not Alex Stefan of 39 Wellington Road, Warburton. Furthermore, at no time did I provide you with these details, but rather I hereby assert that you obtained these details from some other person, no doubt under questionable means. Basically imposing himself on the landowner and saying, oh, you need to give me his details. Your notice claims that I am the owner of a trailer bearing the number plate, blah, blah, blah. I am not the owner of that trailer with that number plate, as I do not know the person that is. My trailer does not bear that number plate. That's because the person that came here initially took the number plate. He wrote it down without asking me or anything. He just saw it and did it straight away. And I had since purchased another car. And obviously I changed the number plates to the new car's registration. So anyway, that was immaterial.
So the trailer was your car?
No, the trailer bears the same number plate as the car.
Gotcha. Okay.
Here in Victoria, if the trailer is below the width of the car, it doesn't need to be registered under a separate registration.
Okay.
Okay, so The entity you are referring to with the all caps name is a separate legal and fictitious entity and is not me. I, on the other hand, am known by the name Alex Stefan. As you can see, it's all lower caps. I am a living man, and I am the principal of that legal entity and owner of the fictitious name mentioned above. My birth certificate, my birth is registered with the International Common Law Court, birth certificate number blah, 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 and my ownership of the legal entity known as Alex Stefan, all caps, is also registered with the International Common Law Court, registration number blah, blah, blah. My ownership of the legal entity and name known as Alex Stefan is also registered with the PPSR. Copies of these, along with my International Common Law Court identity card, are available upon written request as evidence of my standing. As a living man, my rights and obligations fall under the common law, not under the law of commerce, which means that as a living man, I am not subject to the Land Act 1958, which is what he's relying on to get me removed from this land.
Yep.
The statute you quoted applies to legal fictions only, such as persons and corporations, see a legal dictionary, which are usually identified by the all caps names. As a living man under common law, I have committed no criminal offence, offended and broken no common law, and caused no personal harm to any other man, woman, or even a legal person as such. The items you mentioned in your notice to me dated blah, 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 including 2 trailers, blah, 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 fencing, etc., are not in any way owned or controlled by the above legal entity to which your notice is addressed to. All those items are owned by the living man, Alex Stefan, and said ownership is recorded with the International Common Law Court and also on the PPSR. And written documents can be provided upon written requests. Given that the legal person entity known as Alex Stefan to which you addressed your notice is not the rightful owner or holder of the items you mentioned, said person does not have the legal right to remove said items, nor does said person have the physical ability to do so, as it is not a living conscious being. My right to camp on public land and reasonable use of water from the river is afforded to me under Section 52 and 100 of the lawful and binding Common Law Constitution of the Australian Commonwealth 1900, which displays the royal assent seal of the United Kingdom and of Great Britain and Ireland above the proclamation, and which is the supreme law under which the government of the Commonwealth of Australia operates, including its relationship to the states of Australia.
Can I just stop you for a second?
Go ahead.
In relation to anything that you quote, like you did just then with your Constitution of Australia, somewhere in there you need to, well, you've relied upon that for your own right, but it's something that binds them, or they're obligated to be regulated by those statutes, etc. You got to make it quite clear that it doesn't pertain to you.
Yeah, good point. Very good point. Okay. Yep.
Full stop.
Yep. Okay. Please note, I do not recognise any other subsequent document that is labelled as a constitution, as these have not been approved by referendum as required by law and are therefore invalid, particularly the Australia Act 1986, which is unlawful and invalid, and any subsequent state constitutions. Section 52, entitled Exclusive Powers of the Commonwealth or Parliament, states that the Parliament shall, subject to this Constitution, have exclusive power to make laws for the peace, order and good government of the Commonwealth with respect to, point 1, the seat of government of the Commonwealth and all places acquired by Commonwealth for public purposes. This means that the state government does not have the power to make law with respect to public places. Furthermore, no power is vested in the states to restrict the use of public places. What do you think of that?
Yep. Beautiful.
Is that reasonable?
Yeah.
Okay. Next point. Furthermore, Section 100, entitled Nor abridge right to use of water, the Commonwealth shall not, by any law or regulation of trade or commerce, abridge the rights of a state or of the residents therein to the reasonable use of the waters of rivers for conservation or irrigation.
Exactly.
In dealing with inconsistencies between the Commonwealth and state laws, Section 109 of the Lawful and Binding Commonwealth of Australia Constitution Act 1900 clearly states that when a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. Furthermore, any assertions that the states preceded the Commonwealth are unfounded, as the states came into being at Federation, prior to which were only colonies under the British Crown. Please note that I have a duty to act on these issues and am compelled under common law, specifically Chapter 61 of the Magna Carta 1215, entitled Lawful Rebellion, which forms part of the common law, and which, for the protection and preservation of civil liberties, states when injustice becomes law, resistance becomes duty. The Magna Carta is a treaty which has not and cannot be lawfully repealed by any parliament, as they did not create it. Let it also be known that I am aggrieved by your, actually this one's irrelevant, not irrelevant, but it's irrelevant to this video because I don't need any advice on this part, because basically what happened is the colleague of the guy that came, one of my tents was actually open, the door was open.
Yep.
So he just walked straight in and started taking photos.
Right.
And I actually said to him, "What are you doing? Get out." I didn't say you could go in there. And he just stayed there. Anyway, so I was quite disappointed by that.
Yeah. A bit of an invasion of privacy. However, did you have any trespass notices on the access point is the question.
Well, the point is I was actually standing right there and I told him not to go in and he just kept going.
Okay. Have you got that?
No, there was no sign, but I told him verbally.
Yep.
And he just ignored me. And then the policeman that was also, the two policemen that were there, they go, "Oh, he's allowed to do that. Your tent is on public land." I said, "Okay, well, your car's sitting right there. It's on public land too. Can I just go and sit inside it?"
Yep, exactly. I bet
Or
his answer was no.
Photos? Sorry?
I bet his answer was no.
He goes, "Well, that car is private property." I said, "Well, so is the tent." Anyway,
what a wanker.
That was quite funny.
Yep.
And then I said, "Therefore, this letter is to serve as my written notification that I formally object to your notice of demand pursuant to the Land Act 1958. I therefore request you, Evan Johns, and the Department of Environment, Land, Water and Planning to provide the following as evidence of your jurisdiction over me and the land in question. Number 1, certified proof that I, as a living man and not a legal entity, am subject to and obliged to abide by your demand and the Land Act of 1958 by way of a sworn affidavit and supporting documentation that substantiates your claim. Number 2, furthermore, you have asserted that the land my tents are on is Crown land. Therefore, I request that you please provide to me certified proof that the section of land you identified as Crown land, allotment, blah, 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 was lawfully purchased or obtained from the sovereign Wurundjeri or other relevant sovereign nation who are officially recognized by the Australian Government Corporation, a private corporation registered on the SEC website, masquerading as a legitimate government by the people and for the people, and Parks Victoria as the original sovereign owners of said land." So these guys actually recognize these tribes as they always have those signs. I don't know if you have them up in Queensland, but they have those signs around that say, what does it say? I actually have a picture of it somewhere.
Yeah. It sort of goes to signage of the fact that sovereign Wurundjeri tribe is custodian of the land or something along those lines.
Yeah.
Yeah, right.
Yeah, so they always have these signs around, especially for national parks and stuff, say, "Oh, we recognize them as the sovereign owners, blah blah blah." And so I said, "Okay, so you're saying this land is yours. Show me that you have some kind of a purchase contract, or that you've acquired this land in a lawful manner," which they haven't.
Yep.
They're claiming ownership and control over land that they have no way of proving that they legally have that control or ownership.
Exactly. And a good thing to mention or be mindful about is that one that makes an accusation or alleges something in particular, the onus of proof relies upon them to prove their claim.
Exactly. Okay, so let's continue.
Sure.
Point number 3. Please note that a mere assertion of ownership or control by the Crown Corporation or any government corporation without the provision of lawful documentary evidence demonstrating a lawful exchange does not demonstrate legal ownership or right to the control of the land. The same way that a claim made by any person to ownership or control of a piece of land without the ability to prove it is with a signed agreement from the original owners and showing valuable consideration does not prove you own it or constitute lawful ownership or control. Please note that in the absence of such documentary evidence, such demonstrations of ownership or control and demands or threats of removing me from said land constitute your breach of the Crimes Act 1914, for which you and your department will be prosecuted to the fullest extent of the law, and I will be prosecuting them. So this is going to get really interesting.
Yep, brilliant.
I have reasonable grounds to suspect that the Land Act 1958 was not lawfully enacted. Therefore, I require certification that the Land Act 1958, which you are seeking to impose upon me, is lawfully part of a current legal and valid law act in the state of Victoria. I require certification that this law has in fact been lawfully enacted by the Parliament of Victoria in the Queen's name, as is required to be subject to the Commonwealth of Australia Constitution Act 1900, which was approved again as a result of the 99 referendum. Until provision of the above evidence of your claims by way of a sworn affidavit and supporting documentation, I will endeavour to remove myself and my personal belongings from said land as soon as practicable. Okay, so I've given them the option.
So that's a conditional accepted. So if they can provide proof of claim, you'll be happy to remove yourself.
Exactly. So then I continue. Let it hereby be noted that Evan Johns and the department shall produce proof of claim within 21 days. And I say 21 days because that's what he gave me.
Yep.
In his demand. So I'm giving him the same time.
Mm-hmm.
Normally I would give 28 days. 21 days upon receipt hereof with the affidavit and attached supporting documentation as aforementioned, or Evan Johns and the Department of Land and Water and Planning shall admit and agree that no such documentation can be produced by Evan Johns and the department to substantiate their claims. Admit and agree that Evan Johns and the department cannot enforce the Land Act upon a living man, the living man known as Alex Stefan. Agree that where there is an inconsistency between a law of the Commonwealth and a law of the state, the law of the Commonwealth shall prevail, and the law of the state shall be invalid to the extent of the inconsistency as set out in Section 109 of the Constitution. Agree that Evan Johns and the department are bound by covering Clause 5 of the Commonwealth of Australia Constitution. Agree that Evan Johns and the department willfully and intentionally failed to present proof of claim within the time specified and allotted herein. Agree that the conditions required in this notice of objections are not frivolous or vexatious. Agree to be prohibited from taking unlawful action based on the Land Act against the living man Alex Stefan by way of a penalty or any lawsuit or any procedure. Agree to be prohibited from taking unlawful action based on a law that has not been correctly enacted against the living man Alex Stefan by way of any penalty, lawsuit or any procedure. Agree that no officer or representative of the department or Victoria Police may attempt to perform any act which is unlawful or falsely represents its true intention, and that they and Victoria Police Service are acting in full accord with the laws of the Commonwealth and the laws of Her Majesty the Queen in the state of Victoria, and agree that any such attempt may constitute a breach of Section 43 of the Crimes Act. Agree that the living man, Alex Stefan, has and retains the right to claim damages as a result of any adverse or harmful effects upon him brought about by the actions of the department and its officers. Agree that no further contact will be made regarding this matter with the owners or residents of the reason I said this, for them to stop contacting the owners, because they actually did it 3 or 4 times and he was starting to get sick of them.
Oh yeah,
It
and that
got, it got
burden
to the
would come back onto you as well because
yeah,
you're there doing your thing. You don't need people joining you to that sort of drama. Exactly.
that's right. So it basically got to the point where he was getting sick of it, and he said, "Look, I don't need this." He said to me, "Sort it out," or because he was getting concerned because they also threatened him with a fine as well. So he said, "Look, I don't want a fine. Like, why don't you find another place to move to? Because I don't want to get a fine." So they had him kind of worried as well. So I can understand that. That's fair enough.
Mhm.
So let's move on.
Mhm.
Agree that the Department of Land, blah, 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 and its employees or representatives will be personally billed for all future visits with me on the land in question by phone or any other location, including, but that should be but, not limited to a courthouse, and agree to pay at a rate of $500 per hour per person, plus $500 per hour per organisation in blocks of 1 hour, with the minimum charge being 1 hour per person and per organisation. And there I give an example of what exactly that would mean in a scenario. I agree that this constitutes that Evan Johns and the department may reject this consensual agreement by way of providing the requested sworn affidavit and all attached supporting documentation within the time stipulated in this agreement and in no other written or verbal manner. And Evan Johns and the Department of Water agree that simply doing nothing within the specified time for response or providing answers to the above points, which are incomplete or evasive, constitutes their commitment and agreement to the aforementioned terms of this agreement.
Performance. Yep.
Please note, should you decide to ignore this notice of objection and request for further and better particulars and proceed with an application to the Magistrates Court for an order to have me or my property removed, as indicated on your notice, I require that the court that issues the order provide a sworn affidavit and supporting documentation, including a writ of commission, that substantiates their claim that the court order was made in accordance with the laws of the Commonwealth, specifically that the order was made in a court that operates in accordance with Chapter 3 of the Commonwealth Constitution Act 1900 UK, as was upheld in the High Court ruling of Forge versus ASIC. Should you fail to provide proof that that this order was made in accordance with the lawful requirements, it shall be deemed that the order was not lawfully made and is therefore of no lawful force or effect, and any persons attempting to enforce such order will be prosecuted to the fullest extent of the law. Finally, I take this opportunity to notify you of the legal maxim which dictates that silence is deemed to be acquiescence, a concept that was upheld in the case of Golden Eagle Inns Company versus Foremost Inns Company in 93. And then finally, I sign it, the living man, Alex Stefan. This document is to be used without prejudice to the author and all rights reserved.
What's your acronym NB state mean?
Nota bene, note well.
Okay.
Notice, essentially it means notice. I should probably just put notice there.
Yeah, okay. When you've got in your document there lawful, it should also be legal as well, because that's the system that they operate in is illegal. So they could do whatever they wanted because you've failed to mention legal, because you're stipulating lawful, where if they do something, it's in the legal realm, see? So that there's a big loophole.
Right.
Do you get me?
Okay. Yeah, that's a good point. I'll show you a future letter that I sent them in a minute, where I did use the word legal, but I was always debating whether I should or shouldn't use that, because then it kind of felt like I was putting myself under the legal system as well. So I was kind of unsure as to whether to do that. So you reckon I should?
Well, yeah, that's right. And when you use, certain points of legislation, etc., you've got to put in there somewhere that, that's your law, not my law,
Yep.
or that's your law, or I follow the commands of my Heavenly Father found in the King James Version, 1611 or something there, because
Yep.
as I say, they operate in the legal realms, and sometimes they believe that they're in the lawful realm. So legal, lawful, therefore just covers
Yeah.
it all.
Okay. I'll do that.
Yeah,
So
fantastic.
21 days later,
Mhm.
I then sent them a reminder notice. It's
One
pretty much,
moment.
yep.
One moment before we go. Now, with
Mm,
here, obviously, you rebutted them within 72 hours of receiving the notice that they sent you, correct?
same day.
Same day. Wow. Don't muck around. Now, was
Mm,
there now one thing that I also will mention? Now, you've mentioned for them to sort of rebut point for point. Else it
hmm
will be seen as non-response, and you agree to what's within this instrument.
mm,
Now, it's a double-edged sword. So, on the respect of asking them or requiring them to do such a thing under penalty and perjury, full commercial liability, now it is you should be doing that also, because it's a double-edged sword. So you could become vexatious, and if you do, which you're not, and you wouldn't, but that's needs to be the case also. It's like
Yeah,
me
I did
trying to
that.
execute a perfected lien without
Yep.
without turning that into a commercial instrument.
Yep. Yeah. So what I did was I took their notice and actually went through it point for point. So that's how I actually came up with what I wrote.
Yeah, I see that. It's a great rebuttal. It's solid.
Yeah.
Besides those
Yeah.
points that I mentioned, but
Okay.
it's still pretty solid. I mean, but they're the things that I picked up on. That's all, and that's why you brought it to my attention. Correct?
Yeah. Yeah.
Yeah.
So when I'm addressing their stuff point for point, should I actually mention what I'm referring to in their material? Is that what you're saying?
Well, yeah, that would be helpful in relation to. Do they
Okay.
have
In
it,
relation to, yeah.
or in correlation to whatever? But did they have point for point in their
Uh,
correspondence to you or their notice?
no, that was just a one-page notice, 1A4, and it only had one paragraph on it. There wasn't really much there.
Yeah, cool.
Yeah. Okay, so then after 21 days, I didn't hear from them. I sent them a reminder notice, giving them a further 14 days. And then I didn't hear from them based on that either. I then sent them a legal notice of default. By the way, in the previous one, in the reminder notice, I actually did add some stuff.
Right.
I added some court cases. I didn't change the content. I just added some further court cases to show them why I was asking for certain things.
Yep.
Is that okay?
Yeah, that's fine.
Yeah, I thought so.
Yep, because it's something within their system. Everything that you're mentioning, all these laws, legislation, statutes, whatever the case may be, constitution,
Mm,
what regulates them as a corporation. So
mm,
anything that pertains to a court case, Supreme, High Court case, again, strengthens that because it's what regulates them.
mm,
So
mm.
that's fine.
Yeah, so yeah, it was probably about a page longer, the second one. Then I sent this legal notice of default, which is just a one-pager.
Mm-hmm.
And it basically just states that they failed to provide proof of claim. Do you want me to read this?
Yeah, sure.
Okay. On the matter, notice of demand made pursuant to the Land Act 1958 and dated blah, blah, blah. Know all men that I, Alex Stefan, care of this address in the state of Victoria, did on the 11th of May and on the 1st of June formally object to the claim made by Evans Johns in the Department of blah, blah, blah. That I am subject to the Land Act 1958 and that my property was located on the land that is lawfully owned and controlled by the Crown. That the Department of Environment have a lawful right to remove me from said land, and that the court orders issued against me pursuant to the Land Act are lawful and binding upon me. The claim the claim by Evan Johns and the department was denied as it was completely unsubstantiated, and Evan Johns and the department were directed to provide within 28 days and a further 14 days a sworn affidavit and supporting documentation substantiating that I, as a living man, come under common law. I, as a living man, under common law, was subject to the Land Act 1958. Evidence that the land in question is lawfully under the control of the Crown and the DELWP. That the Land Act 1958 was lawfully enacted. As Evan Johns and the department, being fully aware of the terms of my objection, failed to provide any documentary evidence in support of their claim within the time period specified, they have defaulted in respect of their claim and have admitted and agreed to the terms of the objection tendered. Wherefore, I now, in the presence of a justice of the peace, acknowledge and accept the default by the department as agreement, settlement, and closure between the parties. And then it was signed by me and witnessed by JP.
That's fantastic, mate. Brilliant. There you
So
go.
is there anything there that you reckon I left out?
No.
Okay.
No, that's fantastic. You've got your agreement and your agreements that none of it binds to you. And yeah, you can do as you so choose, as long as you win nobody.
So 14 days later, I think it was, I then sent them a notice of private settlement agreement, which basically, the crux of it states, copies of all relevant documentation, including the original request for further and better particulars, the reminder notice, and the notice of default are attached as evidence of the private settlement agreement between the parties. Any interference in this private contract by any third party would constitute an unwelcome and unlawful trespass, as well as a violation of oath of office that such third party may be bound to uphold. Notice to principal, notice to agent. This was also witnessed by JP and one other person.
Fantastic. You just created some nice, positive, secured layers of law between you and this corporation, brother. Good work.
Okay, so what happened then is I received a, give me a second, where is it? This one. Okay, I received a summons. So they didn't reply to anything.
And agreed upon what you've just stated.
Yep. So the magistrate's court, pursuant to blah, 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 that's got the complainants and the defendants listed, and due to appear on the 18th day of September 2020 in Shepparton. And it's signed by the registrar from the Seymour Magistrates Court. So I wrote a letter to the court.
Beautiful.
And the letter, where is it? No, it's not this one. Where did I put that letter?
Not
Give me a
a
second. Let me just grab it.
Sure. Take your time, brother.
Okay, letter to Magistrates Court. Okay. I had fun with this one, to be honest with you. I quite enjoyed writing this.
Brilliant. Yeah, they can get quite fun.
It actually is not bad. I actually don't mind it. So it's got me, Alex Stefan, my address, blah, 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 the date, the presiding magistrate. Okay, so here's what happened. I rang the Magistrates Court and I asked them, who is the presiding magistrate that'll be dealing with this case? And they said, we don't know because the magistrates are only allocated to cases the day before.
Right.
So that's a problem because I was not able to actually name the individual. But I found a way around that. So this is going to be the first of 4 letters that are going to go out to the court as well. It's basically the same thing that I did with the department.
Mm-hmm. And yeah, by the looks of it, you have a fair bit of time between the 18th as well, so you should be able to get a default going on.
Yeah, not only that, I could actually adjourn the case if I wanted to give me more time. You're allowed to do that.
Or perhaps do a counterclaim in the matter and get the judge to order the judgment that's already judged.
Yeah, I was thinking that too. Exactly. So you reckon? Actually, that was what I was going to ask you. So do you reckon I should do a counterclaim?
Yes.
Based on what you've seen so far?
Yep.
Okay. Now here's the problem. Here's why I'm unsure about doing that. If I file a counterclaim, am I not giving jurisdiction to the court to be a deciding factor in this case? Isn't the whole point that I want to tell the court that they don't have jurisdiction over me or the case?
Well, the thing is that they're not making any decisions in the matter because it's already judged. It's a default judgment. Therefore, that you're using them to merely just order the judgment made in that paperwork.
Oh, really? So
I
you
mean,
don't think that by
I'm not a guru when it comes to courts and all that sort of thing. That's not my
sure.
forte, but I would
Yep.
presume, and if anyone can correct me, please do so.
Okay, because yeah, I'm just concerned that I would be standing in front of the judge, essentially telling him that he has no jurisdiction, and then at the same time, I'm asking him to adjudicate something. It kind of it's a contradiction, don't you think?
Yeah.
Okay, so that's why I wasn't sure. So, but I do like your idea, and I would actually like to do that, but I'm just unsure about it. That's all.
But in that case, there also, as you're coming in as the principal creditor in relation to the person, Stefan, estate, uh, you will be putting him in a fiduciary position. So therefore, while he's at it, he may as well just order upon the default. So
Right.
you could come into the matter as who you are. But then again, I mean, walking into the place and even doing anything with those guys, does sort of compromise that standing, I would presume, huh?
Yeah, exactly.
Mm.
Okay, it's something to think about over the next few days. I'm trying to make up my mind. I might talk to a few other people and see what I can come up with. Anyway, so let's move forward. This
So,
one I think.
but I
Yep.
would perhaps consider when I do some correspondence with the Office of the Magistrates Court, Victoria Shepparton,
Mhm.
to the registrar, I would bring him to the light that there is a default there and that the matter is already been sorted.
Okay. Um, that's what I've got in this letter here, which I've already sent to the magistrates court. I sent this on Friday. So
Would
they'll
you care to just quickly scout over that one, just to sort of give a
yeah.
finesse to the whole
Let's go
scenario?
through it.
Yeah.
Let's go through it. Yeah. Okay. So in the matter of the department versus Alex Stefan, for this court case scheduled on that date, dear magistrate, let this serve as my formal motion to dismiss based on the following brief notice to defend, pending my motion to dismiss and request for further and better particulars. So this is the brief in support of the dismissal, okay? This is about a page long. Number one, on the 11th of May 2020, I formally objected to the claim made by the department. This is the registered post number. Always send everything by registered post.
Why is that?
Because I want to have proof that I sent it and that they received it, because chances are they'll probably say, oh, we don't have that. We never got that. Can you please, do you have any proof that you sent that or that we received that? So I have proof that they did. I actually have
So very important to have preeminent record keeping when doing these things, guys.
Exactly, yes.
So
Very important.
service of delivery, signature upon what is it? What is it called?
Signature upon delivery, yeah. Proof of
Exactly.
delivery, yep.
Brilliant.
And by the way, I keep records of all of my proofs of delivery. So the green ones are all the ones that all letters that I've sent. And these are all the proofs of delivery here. I keep a spreadsheet of all this. I'm very particular. And these are the ones relating to this particular case here. These are all the letters that have already been sent.
Yep.
And these two that are not green were sent on Friday. So I'll be checking those next week to confirm that they've been received.
Okay, confirm received, turn green. Fantastic. That's great.
Yeah, so this is how you keep on top of your paperwork.
Right.
Okay, so, and I informed him that I would remove my belongings from the land in question if he could provide me with proof of claim within 21 days, and that his failure to respond would constitute his agreement to the terms of the agreement stated therein. To date, no reply has been received. Number two, on the 1st of June 2020, I sent the department a reminder notice, registered post number, blah, 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 providing him with a further 14 days in which to supply me with his proof of claim, and reminded him that his failure to reply would constitute his agreement to the terms of the agreement stated therein. To date, no reply has been received. On the 22nd of June, I sent the department a notice of default, registered number, blah, 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 due to non-response. This was witnessed by a justice of the peace, which constitutes a court of summary jurisdiction and is therefore binding at law. Number four, a notice of private settlement agreement has also been sent to the department which was also witnessed by a justice of the peace, registered post number, blah, blah, blah. The agreement clearly states that any interference in this private contract by any third party would constitute an unwelcome and unlawful trespass, as well as a violation of oath that such third party may be bound to uphold. And that's one of the reasons why I didn't want to file a counterclaim, because I've pretty much already said that, you know, it's a private settlement agreement. So that's why I'm a bit...
So perhaps the judge or the magistrate would see that and just basically throw it out and said, look, we cannot, you know, we can't be a third party in this because it's private and it's already been settled. Like, get out of here.
Exactly.
Yep.
As such, Magistrates Court Victoria, ABN number, blah, 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 has no jurisdiction in this matter, nor do I grant such jurisdiction. Furthermore, by bringing this action forward, the department is in breach of contract as per the previous 4 letters that we read. Number 6, in my correspondence to the complainant, I informed him of my standing as a living man under common law, and it appears per the complaint and summons that I have received that he and the court have acknowledged this based on the fact that the styling of my name has been corrected to lowercase as compared to the complainant's initial notice of demand. So let's go back there. And you'll notice that they've corrected it in the summons. Furthermore, government fictions and corporate fictions such as the department, ABN number, blah, 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 cannot contend with a living man per the following cases cited below. So
just go back to the summons again.
Yep.
So where are we? Alex Stefan, yeah. However, they didn't put a colon in between the surname. Therefore, the surname is joined to the Christian name. Therefore, the surname is above and beyond the Christian name. Hence the.
I know, and I think that would be because they didn't know why the colon was there, so they just removed it.
Yeah, but when there's something in particular there and it's to be adhered to, well, you need to put it there, right?
Yeah. So
yeah, but that's just for anyone that may not be aware that if you look at the legal definitions of a surname, Christian name, etc., the way that it's written there, Alex Stefan, it is still putting you in their jurisdiction as the surname is above and beyond the Christian name when it's joined.
And further to that, they've used the word Warburton in all capital letters. And they've also added the postcode.
That's right. And in particular, when you mentioned that, you are in there, but with the uppercase and all lowercase, which adheres to land rather than a corporate trading company.
Correct.
Owned and operated by Vic. But then again, let's have a look at that. Vic. What's Vic?
Yeah, that too. Yeah, VIC is also the corporate. Yeah.
But that's the thing up here in Queensland. You know, I come across QLD. Now let's killed. I mean, I don't know what that means. Now let's look in the interpretation of that. You know, a Q, a full stop, an L, full stop, a D, full stop. That I have no recollection or any correspondence or relation with anything like that. It's out of this world.
Yeah, exactly. Anyway, so let's move on. Number 7. Furthermore, the department and the magistrates' courts are both legal corporate entities as opposed to lawful government organisations because they both bear ABN numbers. An ABN number stands for Australian Business Register or Australian Business Number. So if they have an Australian Business Number, then that means they are a business or a company. Therefore, unless a valid contract can be produced in which it can be shown that I have an obligation to the corporate entities known as the Department and the Magistrates Court of Victoria, it will be deemed that no obligation placed upon me, that there is no obligation placed upon me and no jurisdiction exists to proceed with this case. Therefore, based on the above and attached documentation, I reject the command to be and appear in Her Majesty's name. Very important. So going back to the summons. down here, command you to, in Her Majesty's name, to be and appear. So
Very
isn't
good.
that interesting? How they're not asking, they're not telling, they're commanding.
Yeah, like you're at post or something.
Yeah, I find that very interesting. I was surprised when I saw that, actually.
That's right. Command, which is a military term, but when you have done any correspondence, I've noticed that you have, I've seen only because I'm literate, that the post code that you use wasn't really there, but it wasn't. So thus, you were not at military posts. So how can you be commanded when you're not even part of the military?
Correct. Okay, so I reject the command to be and appear in Her Majesty's names as worded in the summons, pending proof of your claim and presumption of jurisdiction, as requested below in the request for further and better particulars. That any legal or corporate entity has a lawful right to command or require anything of any living man, noting the cases cited above and below. As such, in the absence of a valid proof or a valid written agreement or contract, I instruct you to dismiss this case with extreme prejudice.
Definitely.
Okay, so here is my request for further and better particulars from the court. However, after taking judicial notice, and judicial notice is a technical term, it basically means that it's on the record, of the above points, as well as the points made in the attached correspondence, if the magistrate court still feels that this case should proceed and that the court has jurisdiction in this matter, and after taking notice of my identity and standing under common law, and my standing as principal and beneficiary of the legal entity name, which is a Sescovy Trust, known by the all caps name Alex Stefan, copyrighted, I hereby require that the court provide me within 21 days a lawful affidavit responding to the following questions point by point with supporting lawful evidence for each claim. So this is what I'm asking the court to provide.
Okay.
And I've put headings in each, there are 3 separate sections.
Yep.
The first one is headed, your jurisdiction over me and the subject matter. A, does the magistrate's court have jurisdiction over a matter that has already been settled by private settlement agreement? If yes, please state your reasons with supporting evidence for your claims. B, does the court have common law jurisdiction and jurisdiction over living men and women under common law? If yes, blah, blah, blah. Does the court acknowledge that no officer can acquire jurisdiction by deciding he has it? And then I quote a court case where the judge said, the officer, whether judicial or ministerial, decides he has jurisdiction at his own peril. And that was Middleton versus Lowe.
Brilliant.
If no, please state your reasons with supporting evidence for any claims. Does the court acknowledge that fraud is committed in the unlawful procurement of jurisdiction per free? So these are basically all court cases that I'm citing regarding jurisdiction. Okay.
Yep.
Does the magistrate acknowledge that a void judgment is one that has been procured by extrinsic or collateral fraud, or entered by a court that did not have jurisdiction over the subject matter or the parties? In this case, it's neither. They have jurisdiction over neither. Does the court acknowledge that a judgment pronounced or order issued by a court without jurisdiction is void? Does the court acknowledge that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for an examination at the suit of the state? The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited, and this is Hale versus Henkel. Note that there is no agreement between me and the complainant, who is a corporate entity, and if no, blah, blah, blah. I require that the court provide a sworn affidavit and supporting documentation, including a writ of commission and the presiding magistrate's oath of office that substantiates their claim that any court order issued will be issued in accordance with the laws of the Commonwealth, specifically that any orders that are issued by a court that operates in accordance with Chapter 3 of the Commonwealth Constitution Act 1900 UK, as was upheld by the High Court ruling that I mentioned in my previous letter.
So many citing of such solid court rulings, brother.
Does the magistrate acknowledge that the entity known as the Magistrates Court of Victoria, all caps, having the Australian business number, blah, 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 is a corporate legal entity? If no, please state your reasons. Does the magistrate acknowledge that as a corporate legal entity, the Magistrates Court has no jurisdiction or judicial power over the common law living man, Alex Stefan? Okay, so that's the end of jurisdiction. I
see a lot of as king there. You're presenting yourself as a king there, Alex. Doing a lot of as king.
That's right. Yeah, asking. Yeah.
Beautiful. Loving it. Very solid.
Okay, so this section is called My Lawful Standing, and this is me demonstrating to the court who I say I am. Does the court acknowledge my standing as a living man under common law and or the birth and ID documents issued by the International Common Law Court? So with this letter, I actually included certified copies of my birth certificate, ownership of fictitious name, and all the PPSR notices as well.
Okay.
They were all attached to this letter.
Okay, so in relation to the common law court, you have ordered your hard copied, sealed documents from the UK, correct? And then you've got them signed off, witnessed as original copies of those, yeah?
Correct, exactly. Okay. So I got copies from the UK sent to me, and then I went to a JP and had them copy them and then certify them as original and true copies.
Brilliant.
Yeah. B, does the court acknowledge my standing as principal and beneficiary of the Sescovi Trust, known as Alex Stefan, all caps? If no, please state your reasons with supporting evidence.
You're turning this court case into a bit of a probate court there, I see, Alex.